And the topic of this year's forum is building future courts. And what we intend to do during this forum is to have this Justice Innovation Lab that we're sitting in, but also offices upstairs. We want to turn it into a market, a workplace, where our participants work on ideas that all revolve about the future of courts, and the courts of the future, actually. Now, in the run-up to this forum, we are working on a trend report, which more or less helps to establish the agenda of the forum. And what we do in this trend report is we explore together with external professionals like yourself, people from practice, people from academia, several topics that we think are connected and are crucial for thinking about the future of courts. Last week we had some members of the Dutch business community here joining us in a brainstorm about how we could better resolve business disputes in the future, and what would be needed for that when it comes to courts. What processes should we have in place? What rules should we have in place? And this was all based on their current experiences in practice. So the challenges that they see and face, but also promising trends and innovations that they somehow saw emerging somewhere. We've also discussed coping more effectively with labor disputes or with family disputes. So we tried to make it really concrete. And more as general topics, we've also been discussing courts and money. How can we keep the courts financially sustainable? But also the different strategies that we see courts all over the world are using. And many more. You can find all the blog reports and the work session reports on the project blog that we have. It's futureofcourts.org. There we also have a list with topics that we still will discuss. And that's the context indeed for today's session on evidence-based processes. In evidence-based processes, I started with the statement that evidence-based practice is gradually expanding. You see evidence-based management, evidence-based education. I think one of the more developed domains is evidence-based medicine, where people in hospitals or in health clinics more and more work on the basis of protocols or decision rules that have been vigorously tested through research. And that's actually quite funny, because if you look at the history of medicine, this used to be a domain where people experienced, clinicians worked from principles and general rules, and on the basis of their expert intuition came to decisions or operated people, actually. And this gradually has developed into a really evidence-based domain. And when we look around justice systems all over the world, especially in courts, we also see this tendency, this trend towards working more evidence-based. I think one of the best examples probably are the drug courts in the US, where they really put in a lot of effort to study what actually helps people who are drug addicted and who commit petty crimes to sober up. What type of support should there be at what moment, and how can judges and the court intervene in that mingle of expertise? And they really completely designed drug courts around that. But we also see that divorce procedures have been rationalized a lot on the basis of what works. We know that, I just gave the example, I recently returned from Kenya, and when you read there, when you hear there that divorce in Kenya is still only possible if one of the spouses was cheating or moved from the house or is physically or mentally abusing someone, or is impotent, and these are the limited grounds for divorce. Well, we know, well, this is not really effective when it comes to bringing fairness in relationships of people. Today we will explore a bit the question, how can we move towards effectivity next to normativity in our processes, in our court processes. Of course, as lawyers, we are very much used to looking at the rules to find out what we ought to do, or what we can or cannot do in a procedure, in a process. And this perspective of what works, what can we do that actually helps us to get to sustainable solutions is less highlighted. And what I would like to do with you today is to ask of you what you see happening in the courts that is really effective. And when we ask the question of effectivity, of course we should define effectivity somehow. I try to really loosely do this. You can see it here. And my really loose definition of effectivity would be something that yields acceptable results for the immediate parties involved, the legal community, of course, but also society at large. And often when we talk about society at large, somehow money is involved as well.
Can I ask a very silly and maybe annoying question? Why should it be useful for the legal community? Aren't they just servants to make it work for parties and society? Or is that not what you mean, or am I off the mark? Maybe it's a question.
Good question.
I mean, if effectivity of courts, we as legal community have to make sure that they are effective. But should it make us happy?
I would like to reflect the question back to the group.
Salaries and all that.
Yeah. What do you think? Should acceptability for the legal community be one of the criteria defining effectivity when it comes to court processes?
I think it depends on the type of case and the range of alternatives available. Because in some circumstances the legal community are going to be decision makers between choosing process A or process B. So for instance, do you go through a commercial court, do you go to arbitration? And so actually if there is a process that doesn't work for the legal community, they're much more likely to steer the parties in a different direction.
That's good.
Yeah. So can I boldly translate this into keeping or expanding market share? Is that a step too far? Yeah.
Helping with choice.
Yes.
Choice architecture. I mean, they're part of the choice
architecture. I like that.
And I didn't invent that, so that's true. The legal community is important in the choice architecture. So, yeah.
And to be attractive, is you have to be transparent and clear what you want. So, as a member of the legal community, when I know what to do, what is asked of me, I'm happy, and I get more effective, and the whole procedure, my client will be happy. We're all on the same page, so it is an important feature.
Yeah. So the legal community is in essence, it's working towards the same as parties, working towards a solution. So you must include them, or you can utilize them.
Yeah, because you sometimes end up in situations where the judge is looking at the lawyer is looking at the judge, and they're both going like, what do you want from me? Not being able to communicate about what is needed in a certain procedure.
Yeah. So you need them to support the parties in a procedure. Is that
realize each other's needs and be clear about it.
Yeah.
I think about, for example, in the divorce procedures, if it is effective that the legal community or the judiciary takes more time for a hearing. And that's really effective for parties. But if the consequence is that you can do less hearings, then then you can do minor cases, and then it's not effective for all the divorce cases where an intervention of judges is needed or something. I'm thinking.
So I'm thinking. Working within the reality of limited resources, would that be the, or how what should I put here to
me that fits on the society at large. So this is, if it's very effective for the parties individually, it might be unaffordable for society at large.
At large, yes. Yeah. But at the other case, if with more time for hearings, parties don't escalate and de-escalate, and then it can be society at large a lot of resolving problems. But it is not as simple as we think. It interacts with each other.
Yeah, for sure. Yeah.
So put it back. We have these three now more richer criteria. Could this work as criteria for effectivity, or should we still add something or refine something?
Access to alternative dispute resolutions in terms of society at large. Reduce costs.
So that's already working towards a solution rather than defining the criterion, I think.
Yeah.
I would imagine that you would then, when you go a little deeper into particular procedures, you then have effectivity for those procedures.
Yeah. So if we try to make it more concrete, it's going to help, perhaps. Yeah.
And maybe there's one thing, but that's legal community, lawyers or judiciary, it must be transparent. Maybe it's just the same as you say. What is your role and what is your responsibility? For example, as a lawyer, if it is more effective that the judge helps more solving the problems of the party, and then what's the role of the lawyer who is companion the parties?
Facilitate to guide people.
Is their role clear? Is their responsibility clear?
Can I write it down as a question that we might want to ask ourselves? What can lawyers contribute when it comes to working towards evidence-based processes?
Yeah.
Could that work?
I think.
Okay. So let's assume for now that these three criteria, in general, are workable when it comes to thinking of effectivity. Lawyers, it is implied that lawyers do have a role in this.
Yeah.
Maybe I can ask you now what you see happening in our courts or in the immediate environment, maybe in your law firms, what really is effective. And I wrote down some things that we found during the earlier work sessions, and some studies that we did before shows that specialization of courts really helps to work faster, so less burdensome, and to come to really acceptable results. It's a paradox, but standardization does as well. When it comes to standardization, for example, you can think of a very simple divorce where both of the spouses are employed. There's a small, there are two children, they don't have a lot of debts, and they have a rented house. These are the bulk of the cases that many of our family courts face, and they can be dealt with more or less in a similar way. So having really good protocols there can work. So that might be standardization. Yeah, smart IT integration also helps to work more effectively. I know in Scotland, for instance, there's a very sophisticated video conferencing software already being used in the courts, and this of course also comes back to the money issue. but also, the time resources that people have to invest. When it comes to distributive issues of disputes, many, at least private law, but also criminal law issues in the end, they have one of more distributive issues. How much child support should there be paid? What is a reasonable amount of compensation that a perpetrator has to pay to a personal injury victim? How much years of prison should this burglar get? We see there a lot of grids and schedules, formulas, or sentencing guidelines that have been developed that also show that it really helps in two ways, namely making sure that equal cases get treated equally, but it also helps people to settle on these issues much easier. And this is also the strengthening of the ADR methods, of course. We have some other things that we see as well. What do you see, which is not on the list, or which is a concretization of the things on this list that really is effective and that could be a first step towards evidence-based processes?
Well, just to give one example, maybe of interest actually in terms of the digitalisation work that you're doing. One of the other firms in London has developed a system called CourtNAV. So it's driven by the fact that the legal aid system in the UK is sort of contracting rapidly, and the money that goes with it. So CourtNAV is, when it gets up and running, is going to be based in the Royal Courts of Justice, so for civil procedures, and it will enable litigants in person to go on and file their claims. So they don't, and it's a very sort of simple process for them to follow. It's been developed in a way that kind of prompts the right thinking and the right questions at the right time as you go through the forms. So it's to eliminate, legal aid solicitors that aren't going to be there anymore. So to help people access justice when they're going to have to do it themselves.
Well, that's very interesting. Yes.
Yeah. And it goes to the money, basically.
So this is a very promising development that will be launched soon. Are there any other examples that you can think of?
I don't know if it is an example, but I think that early case assessment is promising. But that's maybe you have examples, because in Holland we don't have, but we think that it can be interesting. Just not evidence-based, but
not yet. Yeah.
Not yet.
And can you give a concretization of what you mean?
Well, it is a combination of case management and mediation skills in court. Dus that soon if there is a case filed, that the case management starts with a case assessment. By the judge or by the paralegals or the...
They have it in administrative law. The goal was to have every case in court within 3 months.
The new zaakbehandeling.
So everybody has to be present and just to figure out, okay, where are we at, what is needed, and to become more efficient. Also informal in language and presentation, which changes the role of the lawyer, which makes the lawyer always nervous because his role gets pushed back, and the client is more important always. Also as an experience, and if clients are seen, they are less likely to keep on litigating and more likely even to accept unpopular outcomes. So, but it's not. Haarlem did it for a year very, very well, and now they're slacking as well. It's based on pressure and how many cases there are.
Yeah, so
if courts can live up to that kind of.
So this was a costly.
Or very efficient.
Yeah. Okay, but why are they slacking you?
I don't know.
Okay.
And we have an example. That's called comparitie na aanbrengen in appeal. This, as soon as
yeah, this is still there.
I should do this.
there's a filed in appeal, then the judges in appeal invited both parties to come to talk before the other party has sent his reaction, how we call it.
Have these more or less systematically been reviewed, and do we have data on their effectiveness?
I know that here in The Hague, the Court of Appeal, do monitoring his own practice, and I've heard that 50% of the cases people resolve.
What about things like the consumer court committees that we found in Kenya? So what works in practice is if you as a court know what works in practice. So you have a system to know what works in practice, and you're constantly looking for that. You make that part of your organization. It could be an SMS that you send to everybody who's had a procedure and ask them whether they were happy or not. The court user committees in Kenya, I find quite innovative.
Yeah, absolutely.
But just so the evidence base is to have something evidence based. If it's evidence based,
exactly.
that something evidence based works. Go.
Yeah, this is
That's what I'm trying to say.
what they do at least in the courts in Nairobi, but I believe throughout Kenya, is they mapped out all the different user groups that populate their courts. So it's not only parties, but also big law firms or legal aid organizations or child protection services, all these different groups. And they have representatives of these different groups in what they call the court user committee. And I believe every month or every 2 months, they have a big session with all these user groups, and they simply ask, okay, what do you run into, and what can we help to make your lives better and easier, basically. So what do you think we should change and should improve? I think that's.
Yeah, they had a really silly example, and one of them said, "We need a toilet."
Yeah.
They did not have a toilet in the courtroom.
I've read an interesting paper that came out last year or early this year by the leadership of the New York Commercial Court, and they give they have general ideas about how to become or stay a world-class commercial court, and an advisory committee of users was also an element of that. And they saw it as essential as of being a world-class court, that you have an interaction with your users. Yeah.
What I think is important, because we also in Holland we have plans to do burger panels again, to ask what they like. But then you have to present more dilemmas. For example, if you ask if the procedure is too long or in time, you always will say, well, I want to know as soon as possible. But if you are invited for a hearing and you have to stay the whole day because your hearing might be at 3 o'clock in the afternoon, maybe for some it is very important, because then next week you can have your hearing if you are prepared to stay the whole day in the court. But for another, I can ask, how long did you have to stay? Oh, I have to wait 3 hours. That's bad court performance. But if you, do you know what I mean?
It's coping with subjectivity.
It's a combining of some dilemmas. Because if you ask the question sec, then you get it's like we have in Holland the stemwijzer. I don't know the pool, the polling of how do you call it? That you have to think about some
to give people some choice, which have costs and benefits at both sides.
Yeah.
Are you in favor of faster court proceedings? Then everybody says
yes.
yes.
That's what
Are you in favor of lower taxes? Yes.
That's I'm looking of a combination of some factors, and then you wait.
So that's a data collection challenge almost.
Huh?
that's a data collection challenge
Yeah.
almost.
But also in the question, or
Yeah. When we look here, we see several times that there is no evidence yet, and that we often have a gut feeling that something will have impact. This CourtNAV, I can imagine this really will have impact, but here it's not running yet. But for other cases, we don't move beyond our gut feeling maybe, or our own experiences. And whereas really working towards an evidence-based process in our courts, it requires more systematic assessment, of course. And this brings up the question: how can we, what are your ideas about why we don't really have these systematic reviews of the processes in our courts? What do you think?
Time and money,
Yeah.
I think.
Time and money. That's, it's always money.
And issues of trust.
Yeah.
Time and money and issues of trust.
Yeah, law depends on whether we trust the system to work, and it's highly subjective, but very, very important. So I think people tend to stay away. They don't want to touch what works because it works, although we don't know.
Don't ask questions. Yeah.
So this is.
I'm more concrete referring at there are discussions of have amateur judges. You know how you say.
Layman judges.
Layman judges. You have them in England, in Germany, and I think they're highly effective. Also to take away pressure, but also reliable. And here in the Netherlands, we're not used, and everybody goes haywire. It's maybe also political people who suggest it are not the most trustworthy and have another agenda.
Yeah.
But their issue of trust are really big.
Also the status quo bias.
Yeah.
We know what we have, but we don't know
Yeah.
we don't have, and we try to avoid this uncertainty. Maybe. I'm wondering, does anyone know of any data about these layman judges and their effectiveness?
I think there in Germany and England there should be.
Yeah.
But they have tested.
Yeah.
It's
So there must be data somewhere.
Yeah, at least it's surprising that almost every country in northwestern Europe, but also France, I think also Italy has it. And there's Netherlands doesn't have it.
traffic court in
There's-
England should were.
We've done researches, I
for
think
us,
by
for the
Olivia
magistrates.
de Roos of so.
Yeah.
But I almost think in England at times there's a movement in the opposite direction in trying to focus more on effectively what are paid judges, because of the perception sometimes that the magistrates are more the amateur judges. And I think there is a question of cost effectiveness. If you've got a fully qualified clerk supporting your lay judges, the move instead has been, well, why don't you replace the fully qualified clerk with a professional judge and then get rid of the 3 lay judges?
But what about caseload? Very interesting.
I mean, I think from a caseload perspective, it's probably easier to have the lay magistrates because you can sustain a much wider panel. But the difficulty, and also there's a cultural perception as well in terms of being judged by your peers, and the magistrates are much nearer to that than having a qualified judge.
And has this been this decision? Do you know this? Whether this is really a rational decision based on data, or this is more maybe a political?
I think it's
way?
more a trend based on costs.
Yeah.
Yeah.
Okay. You want to
No, I was just wondering again why no evidence collected. For me, one of the reasons probably is because we never had the evidence. I mean, it's only in the last 20, 30 years, 20 years maybe, that you could do massive surveys with computers and actually find out very quickly what groups of people are thinking. we're learning an incredible amount about neurology and psychology, about how, Thaler's work and whatever, about why people decide, how they decide, what they decide, how decisions are made, how people make choices. So I think that we're only at the beginning of all that. And then secondly, I often find with evidence-based that we don't always know how to turn data into a practice that changes. And one of the things that is often written about in the Netherlands, that we know really well that crime in the Netherlands has gone down, that the streets are safer. I mean, the data shows everything, and yet somehow that's not being translated into what the Minister of Justice does, because what he does is more policemen, harsher punishment, anything that goes against the data. So clearly there's also an issue of, if you have data, then that doesn't automatically mean that you have a better organization, or that organization can work with that, or that they will work with that, or that they will use it. And courts of today, at least, don't have that capacity at all. The previous Premier Président of the Cour de Cassation in France, he recruited an economist in his core staff for that and nearly lost his job. And when he actually resigned after having reformed the Cour de Cassation, the guy was immediately fired by the next Premier Président.
Is it a question of methodology as well? That has to evolve. How do we assess effectiveness of, I don't know, reforming juvenile justice systems somewhere? How do you?
Yeah, it's we often compare it to healthcare, where at least the criterion for what's a successful healthcare is much clearer. It's you get immediate feedback as a healthcare provider, and the complaints disappear. The patient doesn't come back anymore, and it's much more much easier to measure success. And of course, mediators, they are proud on their settlement rates, but as a solution rate, what does it really tell you? It doesn't tell you anything about the quality of solutions. So people.
But is there a standardization of methodology employed to measure?
Difficult. Yeah, there's some attempts, but we are trying to work on some measurement where you ask people about satisfaction, but not only satisfaction in general, but then more satisfaction with certain aspects of procedural justice or with outcome justice. That's what you can ask people, but it's not a standardized thing. No.
Yeah.
Maybe you have talked about it already, but how is in a big law firm like yours, how is evidence playing a role in becoming more effective? Are there some good examples that courts could learn from?
That's a very good question. As we both sit here and rack our brains.
There will be in some of the kind of commercial client setups, but I wouldn't know that. We've done our own sort of evidence-based measuring, haven't we? But only on discrete projects. I guess we're coming to the answer, but not really.
I would say that there are mechanisms in place around collating people's experience of different dispute resolution mechanisms, and that to an extent there is a lot of internal sharing of knowledge and resource, and I think that has become much more standardized. And I think one of the things that the firm does make an awful lot of use of are things like internal wikis as a way of providing a central resource place where actually you can keep a record of evidence and experience. And I think over time as well, the role of the professional support lawyer has changed an awful lot and become much more essential within our litigation department as a way of collating not just hard law but also looking at experience and practice as well.
Yeah.
I mean, I think...
Sorry, what do you mean with professional support lawyer?
So professional support lawyers would generally be people who have previously been in full-time commercial practice,
Right.
but have moved through to a sort of an education role within the department.
Oh, okay.
And
Okay.
so part of that is looking at producing know-how and resources,
Yeah.
taking ownership of things like the wikis, and also as a way of liaising with the partners within the department to identify the department's priorities and also business needs.
Got it.
And that's something which I think has become much more common
So
practice.
that's a function that did not exist, say, 20,
Historically.
20 years ago.
I mean, I would say when I started about 15 years ago, it didn't exist.
Interesting.
So that's something which is...
Is it possible to tell a bit more about how they assess this? How they set priorities, business needs, or...
I think for us that's probably a little bit tricky because we don't actually sit within any of the practice groups.
Is it
So it's a
firm
black box. Yeah.
Is it firm related or client related?
It's a crossover of both. I would say that for the professional support lawyers it's probably more focused on firm,
Yeah.
and then you have effectively your client relationship teams coming together who will be more client related and structured around a series of client relationship partners and client relationship managers. And
Because this typically seems something for frequent players in courts, like insurance companies or banks to do. And they do, I know in the Netherlands they do. They are very savvy because their interests are at stake, so they do that. They make these evidence-based to make their success in court bigger.
Yeah.
Very much so. So that's why I was wondering which way it...
I think, well, primarily it'll be informing decisions across multiple clients.
Yeah.
And I think US firms have some evidence based in how they conduct litigation, what type of questions they ask to witnesses, and there might even be some statistical knowledge about that. Is that something you see in a UK law firm as well, or is that more expert opinion based type of
Less that we would be aware of, and I think given
You'd have to work with the jury.
Yeah.
So in such-
Yeah, it's
Yeah.
for a jury trial,
Yeah.
it's much more likely to be effective.
Yeah.
I can see that. Yeah.
and I think given the split profession that we have in England and Wales as well,
Yeah.
that also creates a different dynamic maybe within a UK firm, say a
Yeah.
US firm.
Yeah. And practices like you were one of the trendsetters in sharing a lot of know-how with your commercial clients. Is that the kind of things that are tested, whether it really works and whether it really brings in the revenues that you hope by doing that kind of practice?
It is. I mean, one of the innovations that we've introduced, and I think which is becoming more commonplace across the larger global firms, is the idea of client listening exercises. And so actually having people involved in meeting with the clients and not managing the relationship, but actually taking the temperature of the relationship. And they're not part of the client relationship team, they're not partners who work with that business. Instead, they're independent people within the firm.
Yeah.
And so they can come at it from a no-holds-barred basis and ask the client, well, actually, what was good, what was bad, what would you change, how do you find each of these individuals?
Yeah.
And then that can inform the firm's way of relating to that client,
Yeah.
but it probably enables us to be much more self-critical than if it's just a matter of the people who deal with the client day to day, sitting down with the people who are their main contacts.
Yeah.
How are these called?
Client listening exercise.
Yeah, that's a mooi functie.
Yeah, and in a way,
God,
that
that's
links
soft.
to the to what the courts do in Kenya and the New
Yeah.
York
Yeah.
Council, it's,
Client listening.
Client listening.
Oh, that's it.
Yeah.
That's another person. The client
No,
listening.
client listening.
you need a word like a committee or whatever.
A committee or something. Yeah.
I think we introduced
Coach.
But doesn't this kind of tell us that, I mean, so this is only the kind of stuff that a big law firm could do.
Yeah.
Yeah.
But a small, medium-sized, I mean, this is tough to do.
Yeah, but don't you have a trickle-down effect?
I don't
If
know.
big court law firms develop these tools, eventually be accessible.
Yeah, I mean, I think some of them
Or
certainly
customized too.
can trickle down quite effectively. So the use of wikis and the use of online electronic resources, I think that's very transferable.
That's true.
Similarly, I think the principles behind client listening, which effectively involve people not in the relationship, sitting down and working with the client, provided you've got more than one person in your law firm, you can do that. I think it does get harder when you come to things like professional support lawyers, because actually they are subsidised by the scale of the business.
Yeah.
And in some ways it goes to the heart of what is innovative about, well, Allovi, for example. So it's their USP that they will innovate these particular kind of things. So yeah, the generic themes and things can be passed on, but
You have no incentives.
No, you don't.
No incentives to share this
too much.
business.
it's a business edge, I suppose.
And not the
Think of it that
intelligence,
way.
but the method, if it works.
Yeah.
I mean, I work in a very small firm, but we have paralegals who work atypically, who have a different relationship with the client. They're much closer to the client, and usually are much more trusted than the lawyer. No, this is true. In that relationship, you can ask different questions than as a lawyer-client relationship. So you have to amend it to your own firm and sort of clients.
Yeah.
So may I assume that from this session you will take away the idea of client whisper? Yeah.
No, it may tell us this, that, so, I mean, when I'm thinking about a national court system, it can organize also the equivalent of these kinds of things.
Yeah.
But, and it can do that, and it can organize large economies of scale, and then make it possible for big law firms. A lot, this is possible, but then for a lot of other actors, this is kind of tough. So you got to think of ways of enhancing the trickle down, or create incentives to share this beyond the big law firms. Well, I think, you wouldn't want to share too much. You want to share some of it, but not all of it, because you're giving away a USB.
Well, private client listeners can organize it for small firms, but then for a few more, then you are not working at a firm.
That's true.
Yeah,
But in,
on a consultancy.
you have
Maybe
more firms.
that's a new consultancy business.
You
have to have very strict ethical rules in place.
Yeah.
It's also interesting to see that for law firms, they have really clear incentives to work like this, to become more efficient, more effective. That's part of your USP. Whereas for maybe there's also for courts, might be a slightly different situation when it comes to thinking of your USP.
I don't think it might. You don't give a toss, you do your judgment.
Yeah.
And your USP is your judgment, no?
I think it depends on the environment. I mean, I think, say you look at somewhere like Rwanda and the East African community, and you look at the integration which is taking place across the EAC, actually there is an issue about which is going to be the strongest and most robust court system. The question of forum shopping as well. And actually, if you want to attract businesses to locate in your country across the EAC, you need to have a very robust and effective justice system, which does have a series of USPs that differentiate it, say, from Kenya or Uganda.
But it's interesting, who runs that? So would that be, is that something that is thought of by the president of courts, or is this something that is thought of at the level of a Ministry of Justice that says we want to have the best courts in Kenya, or can an individual president of a court say, I'm going to create this little USP for me?
I would say it has to be a cross-sectoral approach that brings in probably your Chief Justice and your Minister of Justice as well. And probably whatever ministry is involved in your regional integration.
Business driver.
And perhaps in some locations, I'm thinking about Delaware and probably New York as well, and London could be similar, that there is an informal interaction between the chief leading judges and the leading law firms to keep that model of bringing in cases and having a great court going. Is something like that existing in London? Is there a regular?
Yeah, I mean there are a series of almost like lawyers user committees that exist between the major litigation practices and the judiciary. And I think that's it's not just something that you would see in somewhere like London. So, for instance, Zambia a number of years ago established a regular practice of bringing together the bar and the bench as a way of, first of all, trying to strengthen the jurisdiction and strengthen legal practice, but also breaking down barriers between those two sectors as well.
I always thought that in Anglo-Saxon countries you had more the concept of being officers of the court, on whatever side you were, that solidarity made that they were more standardized, more easy to talk amongst the different groups.
I think it depends.
In the Netherlands, for instance, where it's moving apart,
Yeah.
we see each other. There's a tendency of being adversaries more than officers of the court.
I think it helps for us that the career progression is solicitor or barrister and then judge, in the sense that there is a greater fellow feeling between each section of the profession. However, I think that the flip side to that is that once you are a judge, there's a sense that you want to remove yourself and differentiate yourself from your peers.
Yeah.
And so in a lot of common law countries, I think there is a real tension between the judiciary and the lawyers.
And I think actually the political context has a big part to play. I mean, in the UK, because of the contracting of the legal aid system, you find that judges and lawyers are becoming more and more close on the way they think about things, because they're being forced to a point where actually the key points about access to justice and the rule of law are really coming under pressure. And I mean, the immigration tribunal judges are working really closely now with the lawyers to try and, think of innovative ways to keep lawyers in play, actually, because so many of them are going to be losing their jobs. So it's, I do think the politics of a particular country has a big thing as well.
I have one other thing with problem with the evidence-based processes. I'm thinking, for example, what you say about nieuwe zaaksbehandelingen. If we have, what I always find difficult is that something can be very successful, evidence-based, but then it is contributed by one person, a leadership of one person who has ruled that regime. And then we say, oh, that works very well, and then we will introduce it in the whole country, and then we are surprised it doesn't work anymore. And then it was because of the contribution of one person, one judge or lawyer or combination of a team who was very successful because they worked 24 hours with a lot of passion on that new procedure.
So it's when it's personality driven and it's difficult to move beyond that towards more.
Well, with innovations, I think it's often personal driven, personality driven.
How to institutionalize.
So you have to concrete the aspects who are successful factors, the success factors, and then you have to how you can explain success.
To distinguish the personal element and the institutional element. You may have to conclude.
Our friends from London need to catch the plane.
Oh, okay.
So unfortunately,
There are some examples of systematic data collection that really work towards evidence-based processes, but we also see that there are many examples of basically innovations that people feel work towards effectivity, will improve effectivity, but that data collection really is one of the main challenges that still remains. Although we see that especially big law firms, they work a lot with knowledge sharing within their law firm, and they see this as part of their USP. And obviously for courts this is different, so unsurprisingly we see far less and less of these endeavors within our courts.